Rejoignez-nous, asseyez-vous s'il vous plaît. Génial. Okay. So, hello everyone. We are delighted to have this third year in a row at the Paris Arbitration Week. We are doing a panel this year in cooperation with our friends at FRA. We never have too much of them, so it's going to be a discussion. Really, we hope we can have questions and participations from people in the room on red flags in arbitration. We will be working out of the ICC Commission on Arbitration and ADR report on this specific issue. And Vladimir, I hope you can explain the genesis and what's behind there. For us, it's of course a theme that is very important at Navacelle, given our investigations, white-collar regulatory practice. And we've prepared a publication which is online on our website with contributions from over 20 countries, specifically on how to deal with arbitration with corruption allegations in arbitration. And you're welcome to go and check that one out. One self-promotion, 10 seconds, to say that I'm delighted that we'll be joined by Maxime Desplat, who's sitting here, who was with Debevoise with me 15 years ago, and he'll be joining on June 1st to lead our arbitration practice here at the firm. So welcome, Maxime. Our panelists, Yousr, I'll start with you. The partner at FRA with over 20 years as a forensic accountant in matters involving fraud, corruption, government contracts, disputes, and internal investigations. And notably, you've led the FRA team in supporting Airbus in the effort reporting to multiple enforcement authorities here in France and the US and the UK, and we all know about that. And there you worked in cooperation with Karl. Karl and thanks you so much for being here as well. You are the head of litigation investigations and regulatory affairs at Airbus. You sit on as an arbitrator, although I don't know how you have time for that from time to time. I was told, or at least online it says. I shouldn't trust what I read online.
Sleep is optional.
You served as the chairman of the governing body of the ICC Court of International Arbitration, and you are a member of the Hong Kong International Arbitration Court Council. You lectured in numerous prestigious universities and have published, I'm told, over 100 articles on various legal subjects. Just the law, is it? Or is it other issues as well?
More articles than readers.
Yeah. Vladimir, thank you so much for being here. I mentioned your role as a co-chair of the task force on addressing issues of corruption in international arbitration, and we'll look forward to hearing about that report. You've represented Russian and foreign companies in a variety of litigations involving oil and gas, construction, banking, and so on. You've acted as counsel and arbitrator, and you are included on an extremely long list of arbitral institutions. So I'm not going to start listing them right now. So we want this to be a conversation. We live in a bizarre time. I'm usually the pessimist, but here I'm hopeful it will be a transition period. Tackling corruption is a significant but necessary challenge to assure ethical and legal business conduct. And the fight against corruption is also a matter for arbitration practitioners. And the idea here is we are going to provide feedback on experience, and hopefully you can go back with a few tools for yourself. So it touches upon issues such as jurisdiction, role of arbitral tribunals, admissibility of claims, validity of the awards themselves. We thought of 7 overreaching themes. I don't know that we'll be able to go through all of them, but we thought we'd start with case law attention to corruption issues, and maybe Karl, you can start with that in a second. We'll speak about the task force with you, Vladimir, on addressing issues of corruption in international arbitration. We'll speak, maybe you can lead the conversation on red flags and what we can learn from compliance programs to use in arbitral proceedings. We'll speak about burden and standard of proof of corruption in arbitration cases, the idea of a green flag, which I mentioned early on, I learned about in the ICC report, procedural and substantive implications of red flags, collaboration between arbitral tribunals and national authorities in corruption matters. So it's a long list. We have an hour. If you don't mind, because I think we have over 100 people online using the microphones, that would be wonderful. And Karl, maybe with you on the issue, on the, whatever you'd like to talk about, of course, but maybe case law also.
Well, Stéphane, thank you very much for inviting me, and thank you for composing a panel of people who actually really have all done this, and really the topic has been discussed many times, but not usually by people who have actual real experience, and I unfortunately have quite a lot of it. Yes, in the wake of our corruption settlement, and it's an unfortunate record to hold, 3.6 billion, the largest bribery and corruption fine in the history of mankind. I hope that record doesn't stand forever. The governments can use the money. But in any case, we had hundreds of these proceedings that then followed as a result of a dramatic shift between the way that we did business before, using commercial intermediaries, business partners they were called, and then having made the decision in the wake of identifying that there was simply no way to clear them. The green flags concept is going to be interesting. I can't wait to hear about it. But in 50 Shades of Red, there was simply no way, and so kill them all, let God sort them out. And God being the practice of arbitration. So in simplest terms, this is an extraordinary time to practice, and I feel unbelievably fortunate to have had the opportunity to conduct these cases during the course of the development of the jurisprudence. And what I can say is the French courts represent the extremes of a spectrum. The lower courts represent a hear no evil, see no evil that is terribly surprising and even disturbing, having sort of waved through some things even in the presence of arbitration clauses on the basis of référé or sort of summary proceedings, and redeemed only by the fact that the Paris Court of Appeals stands out as the #1 shining star example of having defined a jurisprudence that I think should be followed by the rest of the planet in setting a de novo review as an available sort of follow-on from an arbitral award in a case where corruption is alleged. And to my total surprise, some of those that failed at the red flags test in the arbitral proceedings then proceeded to bring annulment proceedings alleging that the public policy would dictate that they should be paid anyway. I don't understand that strategy, but it did produce some wonderful additional jurisprudence from which I'm rather grateful. The 𝐀𝐫𝐿 has also then provided its own sort of polish on this, and I think I'll close with the fact that this stands in sharp contrast to the Swiss and English courts in particular that have not necessarily sort of covered themselves with glory in terms of following the example of the French courts.
Vladimir, would you like to comment on?
I'm impressed. No, I'll tell you how I started to deal with the issues of corruption and arbitration. It was at the time I was vice president of ICC court, and as you know, under ICC arbitration rules, when the award is issued, it's draft award. So arbitrators draft award and present it to ICC court for approval. This is a so-called scrutiny process when ICC court reviews the draft award, either approve or not approve, making comments to arbitrators. So I was chairing one of the court committee meetings, and there was a draft award presented for scrutiny. The story was as follows. There was public tender in one of the Middle East countries. And then one of the European publicly listed companies was approached by a local intermediary, and they asked this European company to make an offer to participate in a bid for this municipal project. So they calculated their price. It was, say, 10 million euros, and then it first sent to this intermediary to review. And the intermediary said, why don't you increase it to 15 million from 10? And if you win the bid, then you will pay me 5 million out of this 15. So they agreed. they made an offer to local municipality. They won the bid. They were awarded the contract, and this intermediary was paid 2 million, and 3 million was to be paid within 1 year. But then something went wrong, so intermediary was not paid the remaining 3 million, and he started ICC arbitration. And arbitrators, and there was no corruption defense raised by this European company. So there was some vague statements there might be compliance issue, but not any serious allegation of corruption, no evidence. So tribunal said, okay, we have an agency agreement. Agency fees were linked to the fact if the bid is accepted, the agency fees are due. So 2 million were paid, 3 million remaining, so we grant the claim for remaining 3 million. So when I read this award, for me, you know, the corruption was staring at my face, obviously, you know. And I was surprised by two others because it was a court committee meeting. We have 2 court members, one, I can't remember, one from Switzerland, another from Germany. And they said, well, Vladimir, I mean, what is the problem? There's no allegation of corruption. What is wrong with this award? I said, yes, there's no allegation of corruption, but if you look into the story, if you read behind or between the lines, you'll understand this, in fact, is payment covering corruption. No way I'm going to approve it. They said, well, Vladimir, but there's no evidence of it. How can you decide other than tribunal decide? By the way, tribunal decide unanimously that the claim should be granted. I said, no way. I mean, you could kill me, you could do whatever with me. I'm not going to pull my signature on it. So the award was not approved. And since that time, I started thinking, you know, something wrong going on with international arbitration. If very experienced arbitrators, very experienced court members believe that if there's no allegation of corruption, then there's no issue. And there were different reasons for it. And one of the reasons was that some of the arbitrators were saying at that time, we are not police officers of the state. So we are resolving just contractual dispute. If there's agency agreement and there's no allegation of corruption, why do we should raise the issue of corruption by ourselves? Some of the arbitrators feel very uncomfortable, you know, in a situation like this one, but because they don't know what to do, they prefer to resign from the case rather than investigate the facts. Some of the arbitrators feel that they need to do something, but they don't know how to do it, because at that time, there was no real guidelines how arbitrators should approach the issues of corruption, i.e. so-called red flags. So this is why this ICC task force on issues of allegations of corruption in arbitration, international arbitration was created, and they recently published a report. There are various tracks dealing with various issues, and track 3 was dealing with red flags. If you have not read it, you could find it on ICC website. It's a very interesting document because it's kind of tool for arbitrators, what you do in a situation when there are allegations of corruption or no allegation of corruptions, what kind of red flags you could see. The basic idea is that, of course, arbitrators are not police, they are not prosecutors, so they don't have tools to investigate the issues of corruption, because if Karl is doing investigation of corruption, he has, various, people assisting, forensic and stuff like that. Arbitrators do not have it. So the basic idea is what arbitrators have, they have just a case file. However, if you look into case file, you could see a lot from case file as it is. For example, and I'm coming to red flags. First of all, industry. Right? Because we know that there are some industries which are highly corrupted areas around the world, like defense industry or healthcare or public services. These are normally industries with high corruption risks. Secondly, you look into the countries, because you have countries with low corruption risk, like Singapore, and with high corruption risk, like, say Russia or whatever, China or Nigeria. Third, you'll see whether it's private company or public company, because in private company, normally you see if a public company is a client ordering services, you see normally more control over the issues of corruption, because private businesses, they don't like when people are stealing funds from them, while you have state-owned company or publicly held company, you have less attention to those issues, although it should be more attention. Then you see on the nature of the contract, if there's agency contract or kind of facilitation contract, where the nature of the contract is not specified. Then you see the amount of fees to be paid to agent, which is unusually high. Then you look, for example, who is the agent, because if the agent is registered in offshore jurisdiction with in BVI, for example, with account in some bank in a strange jurisdiction, this is all red flags. And one of the red flags, pretty funny, I remember I was speaking in one of the conferences, that normally this kind of intermediaries, they don't have website. And then people said to me, I mean, what is the problem to make a website, right? It's not difficult these days. But reality is fancy agents, they normally don't have website, because on the website, you need to put your team who are working on the project, and normal agency companies, they do have teams. They have projects listed, which they've done in the past, and these people do not want to list projects. So,
if I may, I have one recent experience where the consultants actually had a website, but they had no other activity than literally paying bribes. And on their website, they had a list of all their clients available
Airbus.
for you to... No, Karl, you weren't on that list. But literally, they were...
Some of our guys were dumb, but they weren't that dumb.
So basic idea, the idea now is the tribunal, when they look into case file as it is, without any external investigations, that could identify red flags, even if they are not alleged by the parties, if corruption is not alleged by the parties. And then they should ask the parties to provide more documents or evidence confirming that it was a legitimate activity. For example, because it could be a pretty legitimate activity of the agent, but then there should be some market investigations or meetings with potential clients, some people are working on it, history of negotiation, advising how to better structure a deal, and so on and so forth. So there must be records of legitimate activity. And if the party cannot present record for legitimate activity, then tribunal should come to the conclusion that most likely this is activity covering the bribe payment and make it
when you think of all those steps and all those red flags, when you don't necessarily have the right background because you have other areas of competence, who would you turn to? How does an arbitrator know, once they do their own checklist, and how can you weigh in? Do you ask the parties to provide evidence? How do you address that sort of concrete fact finding first, and then determining what has a crime been committed, or is there something beyond mere suspicion?
I believe you need to read this ICC report because it provides a pretty useful examples of various red flags indicators. So if the tribunal will see these indicators in their case files, they should ask questions themselves first of all, whether they're comfortable or not, and then asking the parties. And if the parties could provide, good answers, good evidence explaining what's going on, then tribunal could decide that okay, there's no issue with corruption.
Just to support entirely your point, Vladimir, that people should read this report. It is, it's incredible because it anticipates and lifts from and provides guidance on how to do some of the things that the most effective arbitrators that we saw in this process. And as a result of having so many of them, we had, we simply emptied the ICC's bank. So we got to see many of them in action. And I'll give you one specific example, a German arbitrator. And German arbitrators are special in this, not just because I am one, but because they have criminal liability if they participate, through an arbitral award in an act of corruption. So they are particularly careful. And this particular German arbitrator, a prominent gentleman, I won't say more than that, he conducted a very short, very effective cross-examination, it can only be said, of a particular witness who claimed that he had spontaneously written this letter of one kind. And he had been so meticulous in reviewing two different versions of this letter that he was able to identify punctuation changes and things like that that even our lawyers missed. So it is true, the arbitrator doesn't have the power of police, but they do have the power to ask excellent questions and to search their own souls as to whether those questions are the right ones to ask, because it's not just the criminal liability of the arbitrator that should be of concern, it's the fact that false arbitrations, fake arbitrations, are a known tool. And if you are, as an arbitrator, you may be the unwitting dupe or fool that is being asked to rubber stamp a transaction between two colluding parties who only appear to be adversaries.
Yeah, on that specific issue, you know, very clearly the fake litigation, fake arbitration is now known to every prosecutor in the world, and don't think you can outsmart them. They will not only ask for your consultants, and they will look into the litigation and, you know, and dig into anything strange. So now, you know, you have to look for yet another way to get money out of the company. Yousr, maybe you can say a few words from you know, your experience, you know, investigating corruption allegations, assisting in developing compliance systems, you know, what works, what doesn't, and how our arbitrators, once they've read the ICC book, can you know, use your examples.
Thank you. Where do I start? Because everyone talked about a lot of the points that I had planned, but let's take a step back. Back in 2021, I was engaged by a judge in the US to be a common party to opine on whether or not a contract between a US company and a European company is tainted with arbitration, because the US company was claiming non-payment based on bribery and corruption red flags. So we were reporting directly to the judge, and we had to review everything that was made available by both parties and come back with the fact that, well, the contract is generous, but we haven't seen evidence of bribery and corruption. But the thing is that if you are asking a forensic accountant with an investigator compliance hat, what's red flags, we can talk for hours and hours again. Because what we have seen is, and I'd like to say that the report from the ICC provides a very good roadmap for a person who knows nothing about bribery and corruption. If they look at it and start thinking about it, they have the right starting point instead of starting from scratch. But the matters are a lot more sophisticated than just what's been presented in that report. And I think Vladimir's experience and the fact that he saw that the fee was 50% of the value of the contract, for him, that was a lot more problematic than anything else. I don't mean any disrespect, but not everyone has that same reaction, because some people still believe that it can be too good to be true. So while we will continue with that. But going back, if you're thinking about red flags, or if you're presenting a client who's claiming bribery and corruption on their case, or vice versa, it's really important not only to think of the general bribery and corruption matters as described by the ICC report, but really the one that is really specific to the nature of the transaction. And that may be challenging because you may not have access to all the documents that are necessary to put that picture together. And one of the things that is most important about the ICC report is you have to consider all of these red flags in their totality. It is not just because you're working in a Libya contract and Libya is high on the CPI index that you have bribery and corruption. Not because you have a third-party agent, you have corruption. All of these things by themselves, if you start looking at that, people will not do business. And also, one of the points that was raised, that the lack of a compliance program is also a sign of can be considered a red flag. Well, yeah, it really depends, because if you're dealing with things before the company was mandated to have a compliance program, if you look at the history of France, they had compliance program, but they were not as extensive or as required after the passage of La Loi Sapin II. So maybe at the time it was not really required. We have a US presidency that believes that corruption is a valid way of doing business. So not all of these facts should be taken in silo, and just once you tick the box, you have a corruption case. What's really important also from my perspective is the benefit. Where do you see the benefit coming through? Because if you don't establish an ultimate benefit to either party, then what's the objective of corruption? Remember, corruption, there is an intent to corrupt, there's an intent to defraud, but there's also the benefit that you're receiving, whether that benefit is a contract or whether that benefit is an avoidance of a penalty that you may have had to pay. So there's a lot of factors to be considered when evaluating whether or not you have a fabric that points to a likelihood of bribery and corruption and an arbitration matter. As far as where do we come in as forensic accountant, because I'm not a lawyer or an arbitrator, we come in because we have instructions to either say There is elements of bribery and corruption in this method, and it's really dependent on the quality of the data that is available to us. We can opine, or we can provide a report or an opinion as to whether the company had adequate due diligence or adequate compliance program to prevent the occurrence of bribery and corruption. That can be used as a defense. We can comment on the use of investigation technique to be able to identify or prevent bribery and corruption. All of these things depend on what is counsel seeking to establish with our support. And at the end of the day, an expert on arbitrations, our role is to support the tribunal come to a clear understanding of the facts and circumstances to make that decision. It's not our role to say there is bribery and corruption, make a decision in favor of X or versus Y. Have I addressed all of your points? I can talk for a long time.
Continue. No, but thank you so much. This is very helpful, and you've really sort of segued into the issue of the green flags we mentioned very briefly. And corruption is not everywhere, and you have. Hopefully not in this room, but
yet.
Yet, okay.
But you suddenly corrupted us with promise to have wine after the session.
Yes, but you see, there's enough to disagree here amongst the panelists that no one took a bribe, at least not yet, exactly. So in your report, you give the tools to the arbitrators to identify corruption, and the revolution, and you mentioned the fact you saw that this is relatively recent in France, and when I arrived in France from the US, it was a Stone Age. There was no compliance obligation. There was no self-reporting at all. I mean, the only right strategy was to delay as much as you can, and that was the wise thing to do. Hope everyone's dead or retired and no one cares about the case anymore. There was no PNF. That's 2013. So when we started the firm in 2010, it was mostly trying to explain to French and European clients what was coming. This is the beginning of a huge change, and I think what's fundamental is this sort of reversal of the burden of proof, and now it's for the corporate and arbitrators when they look at these issues, it's for the corporate to show that they have done what was right, and the UK has, Caroline is here just in front of us, their failure to prevent, which is sort of extensive application, and we see it's not going anyway. So green flags. So what do arbitrators want to look for in terms of mitigating factors, or if they have, is it, oh dear, sorry. No worries. What are the green flags?
Well, green flags, so we already mentioned some of the green flags. If the company has compliance program, compliance officer in place is one of the green flags. Secondly, if the company before, it's a tendency here.
Someone did something.
Yes, yeah.
So compliance.
Compliance first. Secondly, due diligence on your counterparty before signing kind of agency agreement or commission agreement. You could, ask questions with counterparty, what kind of activity they are in, provide records of previous activity, audit reports, and so on and so forth. Secondly, compliance clauses in the contract, because if the company is avoiding to sign in compliance clause in the contract, it's also red flag by itself, but if there's compliance clause in the contract, it's also green flag. So if there are measures which make a tribunal comfortable that despite of, some red flags, the company investigated itself, its potential red flags, and came to the conclusion that there are no red flags in place, then it will be considered as a green flag. So it will put comfort to tribunals that everything is okay. Some comfort.
Yeah.
To a point.
Yeah.
So at a certain stage of the early part of the investigation, I must tell the whole story so that you can appreciate how this fits together. That it's fair to say that starting sort of in 2014, there was a feeling among the very top management of Airbus that all was not well, and that maybe their colleagues in the strategy and marketing organization, which is a euphemism for Corruption Incorporated, were not telling them everything. And there were an increasing number of sort of indications that this was true. And upon reflection, the CFO took an incredibly courageous decision and said, I will simply not pay anybody until I see the green flags. So the initial stage of the investigation was a sort of a due diligence process. You know, let's find the few bad apples and let's clear the rest of the apples. There was, at some point in that process, something famously called the oh shit moment, where you realized that really it was a spectrum, it was a continuum, and that the green flags that you mentioned were almost universally present, but they didn't make any difference. The company did have a compliance program. It did have a compliance team, but that compliance team worked for the Fox. So in other words, the SMO was sort of genius in its way because they duplicated every single function in the company. They had their own legal department, they had their own finance team, they had their own compliance team. And there were compliance reps and warranties in all of the contracts. And there were activity reports in all of, for all of the business partners, but they were busily being written by a subcontractor whose job it was to write reports. And he didn't necessarily know anything about what was being done, he just made it up. And in interviewing one of the business partners at one point, hilariously, he finally admitted that he hadn't written the supposed sort of activity report that was put in front of him because it said he was a supporter of one football club when in fact he hates that football club and he's a supporter of the rival football club. And that was too much for him to swallow, so he blew a 200 million claim, among other things, by admitting that he hadn't written these activity reports. So green flags to a point, but enhanced due diligence didn't get us there because it couldn't get us there. And I would say an arbitral tribunal can use green flags as a kind of an indicative point, but the corrupt are ahead of us all there. They've thought of all of this, and they're happy to populate the field with green flags to hide all of the deep red ones.
Well, it's true, but I will say it depends.
Yes.
Because some sophisticated corruptors, they do what you said. Some of them simply don't because they never thought about consequences. So they believe that everything will go smoothly, so didn't bother, you know, to do this fake due diligence, fake compliance program, and so on and so forth. But you're right. I mean, it should not be absolute evidence that there's no corruption in place. That's right.
And it's fair to point out as well that they even had hired their own law firm to train these people how to go through due diligence interviews and say the right things so that they wouldn't be caught saying the wrong things.
I think what's important when you're looking at these things is that the roadmap to the red flags, or the report has it put it, it really needs to consider the evolution of business. Because 20 years ago when I started doing this and doing investigations, it was the bag, the cash in the bag, and you know, we did email review with printed pieces of paper. And fraudsters and corruptors and all of these things, all of these individuals are evolving in their sophistication with the technology. So, forgive me, Karl, but Airbus at one point in time had a certificate that had an adequate compliance program, and you know,
2012.
Yes, it was part of the. So, I think the concept of red flag is you have to consider mitigating circumstances, but you have to take these mitigating circumstances with a grain of salt. And the challenge here is at which point in time will the arbitrator or the tribunal be able to request additional information and additional documentation in an era where everyone is trying to limit document production and the cost of these document production, and you know, not to delay the arbitration proceeding, to provide the tribunal with the comfort that these mitigating factors are actually relating to those red flags that have been identified. So it's a challenge in an arbitration setting because of the timeline, the cost, and all of these things. When you're subject to an investigation, you can't avoid it. You have to go through this. You have to get to the bottom line of that. And what I personally find challenging is that at which point in time an arbitration tribunal can continue pushing the party to get to the bottom answer of that question and satisfy itself without becoming a police or a state or investigating.
I would just note that there are both benefits and disadvantages to being under investigation as the corporate when you're a party, because the benefit is that you are absolutely not shy about shouting from the rooftops the problem. In other words, you would never see an award where a party under investigation would deny the corruption. In fact, they'd be enhancing it. So they'd be disclosing what they could. But this brings me to the other problem, which is, of course, that typically the tipping off rules will not allow you to use all of the evidence that you have, because the state may have an independent desire to prosecute the counterparty. And I will say that tribunals are quite skeptical of that. They're skeptical of the request to stay. They nearly never do. They're skeptical of the point that is made, even with letters provided by the prosecuting authorities, that not all evidence will be made available because of this tipping off point. And I will say that it's almost to the point that they would just rather not know about it. They would rather, and they typically did, review the cases under the reps and warranties in on the civil contract basis, because they were just so deeply uncomfortable. Maybe it was the lack of adequate tools, because at the time when this started, they had nothing more than that wonderful article written by Professor Gaillard, which is one of many legacies that he left us, to work with. And over time, they've accumulated some additional tools, culminating now in, I think, this excellent report. But for the most part, I can tell you, most of them hear no evil, see no evil, but they were happy to look for a contractual breach of a rep or warranty.
Addressing the issue of parallel proceedings when state initiate criminal case or administrative investigation, there are some more documents coming from ICC, and I'm advertising them in advance. And one of them is because this ICC task force is organized in a way that there are various tracks. And track 3 published already a report on red flags, and there are 2 reports, or 3 reports actually coming, one on parallel proceedings, i.e. what tribunals should do when there is a parallel criminal or administrative investigation, and especially when, if there is a request, for example, from court to stay arbitration, whether tribunal should do it or not. And there's also an issue whether tribunal could use evidence which were obtained through criminal investigation, administrative investigation in arbitration, and whether there is a res judicata issue between what tribunals are to decide and what civil courts will decide. There's also one report coming on standard and burden of proof on international arbitration, and one report is coming on duties of arbitrators. Because there's one pretty sensitive duty which is pretty controversial, duty to report. Because arbitrators are lawyers and they're subject to ethical rules, whatever, in which countries they are. And under many ethical rules, not only ethical rules, but under the law, the lawyers have duty to report in case they have suspicions of money laundering, of corruption. It's especially a case for UK, as far as I know, where there are very strict rules on reporting on any suspicions of money laundering. So it is actually one of the reasons why many arbitrators prefer to close eyes on red flags, because they think of themselves, okay, if I investigate it further and find out that there are actually serious indicators of corruption, I'm on duty to report, and I don't know how to report, whom to report, how should I deal with the issues of confidentiality, because arbitration is confidential, whether I'll be in breach of confidentiality or not. So these are the issues which are going to be addressed in further publications of ICC. They'll be released later this year. And there'll be very good answers to these questions.
I can't wait.
Yeah.
We're in a bizarre situation where there's a consultant that's actually filed against a client in commercial court in Paris, basically wanting to be paid for the bribes they've paid themselves previously. And we went straight to the client, on behalf of the client, went straight to the prosecutor's office and the PNF here in Paris. And they said, give us the documents and so on and so forth. And it's all in a country that just will not, provide any documents, and we can't. There's not much we could do except having all our lawyers end up in jail in that country if we go. The prosecutor has basically turned to us saying, you know, I'm not going to interfere in the commercial proceeding if you're not going to help me. You know, you got the deal, you got the contract, and I'm not going to, you know, help you win on both ends, basically, which was very surprising, but it also shows that you don't always have, you know, a very kind ear, including with sophisticated prosecutors, when they feel they've been taken advantage of. And so I feel for the poor arbitrators when you think that a French prosecutor should, you know, feel he has the leeway to take a tough decision, and I think an arbitrator is in a tough spot. So I think that guide that's coming is going to be a hit.
Yeah, again, one of the reasons why we decided it's important to have kind of guidelines, because exactly of that problem. Even in your case, prosecutor who potentially has tools to investigate doesn't want to use these tools, but the problem with arbitrators that they don't have tools available to prosecutor, right? But they still need to make decision. And the solution which was taken in the past is not invention of ICC task force. In some of the cases, you mentioned already, is shifting burden of proof. Because normally, in a normal situation, each party needs to prove its case, right? If one of the party alleges the corruption, the party under standard distribution of burden of proof needs to prove that there is a corruption. But then the question is, how could you prove corruption, because you need to evidence. And people, sophisticated people involved in corruption, they normally not.
Why are you pointing to Karl?
Right? No, I'm pointing to Karl because he dealt with these people a lot. That's the reason. So I'm looking for his support of my statement, right? So these people are sophisticated. They don't normally. They're trying not to leave evidence.
It's a bit of a bell curve, actually.
Yeah, instead they're creating, like a fake evidence that, it's a legitimate transaction. So it's really, in practice, very difficult to the party to prove corruption. So the tools which is available to arbitrators is to say, okay, I understand that the parties alleging corruption cannot provide positive evidence of corruption. But let's look on the other side of the medal. If you are in a legitimate activity, then please provide, for example, auditor's report. I understand your account statements could be confidential, but you could provide to third-party independent auditor could check your banking records for last 2 years and confirm that there were no any suspicious payments to BVI, Bahamas, or whatever jurisdiction like that. That indeed you have staff in your company able to perform the work you pretend that you did, other records. And if the other party, well, let's talk about consultant. We are in the consultancy business. If we are asking for fee for representing the client in a court, sometimes if you're working on contingency fee, saying it's 10% from a case, the other party could say, well, half of it will go to the judge, right? So it's not legitimate consultancy contract that we are not going to pay. But normally lawyers will be able to prove their qualifications, that they indeed, practicing law, they're going to court, they're participating in briefs, participating in the hearing, and so on and so forth. So normally legitimate agency activity would have legitimate evidence, positive evidence. So if the party could provide this evidence, the tribunal will be comfortable that allegations of corruptions are not proven because the other party provide evidence. But if the party would fail to provide evidence, then the tribunal could make adverse inference. Okay. So from the very fact that the evidence is not presented, tribunal could make assumption that the activity was not legitimate. And it's very, this adverse inference, it's a very powerful tool in the hands of arbitrators because it's indeed switching the burden of proof from one side to another side, but this is something which tribunal could easily employ. And I remember a story, I talked to one of the Swedish arbitrators who 15 years ago had a case with Russian, this was very interesting case where the claimant asked the respondent to pay, I can't remember, 2 or 3 million, he mentioned, as a payment for development of so-called technological documentation.
Sounds fancy.
Yes. The contractor consultant allegedly was to provide so-called technical technological documentation, and the respondent accepted actually the technical technological documentation was provided, but did not pay for it. Honestly, it looked like they needed a ward to proceed the payment to the bank, because the banks these days are the major threat to these corrupted people, because banks, they have compliance program and they would not allow payment for consultancy for 2 million without supporting documents and confirmation. But if the one will present arbitral award, especially recognized in the country, that it will be difficult for bank to say no. So these people apparently were looking for a award to cover this contract. So the arbitrator said, okay, can you provide me the copy of this technical technological documentation, was $2 million US. And there was silence on both sides. It was clear. He asked during hearing, can the parties provide me this technological documentation? And he saw on the faces how they were disappointed by the question, because they didn't know what to do and how to respond. And based on that, he dismissed the case. He did not say, though, that he suspected corruption, but he said because the claimant did not prove that the services were actually provided, so he dismissed the claim.
I must admit, if you had asked me 8 years ago what I thought of document production and even of oral hearings, I would have told you that they were generally a waste of time, to be employed only in few cases. In most cases could be done as a desk arbitration. I have completely changed my mind in light of some of the things that I've seen, which reflect very much what you're saying, Vladimir, the role of arbitrator, the role of cross-examination, and I will insist on it, the role of in-person hearings, because there was a significant and stark difference between the ineffectiveness of cross-examination and those roles being played in virtual hearings that were mainly during COVID and those that were done in person, where you could see a far more effective cross-examination. 3 quick examples to illustrate both the spectrum of stupidity that we sometimes were confronted with and the effectiveness in questioning and uncovering it. Sort of a debate over whether certain documentation that had not been provided would or would not be the subject of adverse inferences, and into the principal of one of these companies that claimed that he was entitled to a very large amount of money for having brokered certain deals. Yeah, sir, the documentation that would have demonstrated all of the things that you've just told us about, where is that? And he said, well, I have rooms of documentation. Well, you were asked to provide documentation and you refused to do so. I don't have time to go look for that. So you've made a claim for $30 million. Don't you think that would have been worth your time? Or maybe the time of your staff? What staff? And he claimed that he was the principal of a very large company. So question 2, incident number 2. Sir, would you please turn to this sort of country reports that the technological documentation in this particular case, and could you please read paragraph X? Yes, I've just read that. It's a country report about Asian country Y. Yes, it is. And all right, I'd now like you to turn to the CIA Fact Book, an online publication. I'd like you to read this paragraph. He reads it. Would you agree that the 2 paragraphs are absolutely identical? Yes. All right, now read this paragraph. He repeats the exercise. Now I'd like you to turn to this extract of our law firm website. Could you please read that? Would you agree that the 2 are identical? Yes, I would. Have you ever been to country Y? No. I can go on. But the point being that the importance of the role of the arbitration process, the crucible that is an effective examination of the documents, the cogent application of scrutiny to those documents by all parties involved, the adverse inferences, the ability of arbitrators to focus the attention on the things that they want to know in addition to what the parties are putting before them, and a frank understanding of the position of both parties. A party that may be coming from a country where it's culturally unusual to be cross-examined in this way, where trust is what it is, and a party that may find itself under criminal prosecution and can't provide all the evidence. The arbitrator's brain and experience provides the bridge. And yet, reasonable minds may differ. I had one very significant case where the majority found that they would make a partial award. And the third arbitrator dissented. He said, this is outrageous. This is the most corrupt thing I have ever seen, and I refuse to be a part of it.
Le mot de la fin.
Wow, okay. Okay, so one of the points that we talked about is, as we were preparing for this panel, is the role of a forensic accounting expert, and maybe this is self-promotion, but as you're going through your cases, it's really important. My one advice to you is that if you'd like to bring allegations of corruption, please consider that at the very front of the matter before you even make any filings. Because once you have a discussion with your forensic accountant or whoever can advise you on that, you'll be able to see the merits of the case that you can claim based on the little documents that are available to you. Don't decide that halfway through the case and suddenly you're scrambling for documentation, it's impacting the credibility of your case, and your forensic accountant or your expert will not be able to support the matter, because at the end of the day we're limited to what we can factually present and discuss in front of the tribunal.
I just want to support this idea of using forensic people, special forensics people, because when we are acting as a counsel, and it's amazing how much information they're able to get from public sources, which normal people, I don't know for what reason you could Google, but you still will have difficulties in connecting dots together. But very often they're looking into various trade registered, corporate registered, information on stock exchanges and so on and so forth, and getting pieces like puzzles together. Sometimes you don't have direct evidence, but then you have indirect evidence, but they could fit in one picture.
Like a red flag.
Yeah, and it's very convincing. Yeah, it's very convincing. Yeah.
And that really comes down to, that really comes down to the experience of the person who's looking at that. Because while the report talks about general and specific red flags, there's been years of evidence of typology of corruption. What's the typical scheme of a corrupt activity that takes place in country X? And based on the experience of the person that you retain to have that discussion, you'll be able to adequately present the matter versus someone who would look at all of these factors together and say, I really don't know what to make of it. So, yeah.
And I don't know whether you've seen 𝐁𝐻𝐼 movie on Netflix. If you have not seen it, I urge you to see, because this is a story about the guy who was hired by narco cartel for money laundering. Yeah, and in this movie you'll see various ways how he started the business, which looked like legitimate business to do this money laundering.
And we've seen a number of cases where very large corporations have had to address issues of cartel peddling, if you will. And the current U.S. administration has asked the Department of Justice to focus specifically on human trafficking, cartel, and drugs. So that's an issue that I'm seeing clients with a strong Latin American presence look into and try and have their compliance program evolve towards addressing those specific issues to avoid what happened to Lafarge and ultimately being in a situation where they are financing a terrorist organization, which a number of cartels now are in the application of this policy in the U.S. So yeah, definitely Netflix legal advice. Karl, last word.
Only this, that I think the point that Yousr made is a good one, that these things evolve, and if you're fighting yesterday's war, you're losing. And this isn't just a question of where your data comes from. It used to be sort of an email, and now it's in WhatsApp or in WeChat or in Signal. It used to be the tools that were available used to be the cross-referencing of what we call unstructured data, emails, presentations, letters, with structured data, what you find in the financial accounts. And tomorrow, you know, AI is providing some extremely powerful abilities to look for anomalies, trends, bumps in the data, which sort of the investigation. But what all of these things have in common is that whether if for an arbitration or an investigation or any piece of anything where you're just trying to figure out what happened, the correspondence between the numbers that do not lie and the financial flows that are always going to be your best indication, and finding other indications of where to look, whether it's in the email or WhatsApp or WeChat or KakaoTalk traffic or whatever it's going to be, is going to be the partnership between strong lawyers and strong accountants. And to have only one is to be worse than half blind, because you have a mountain of data and you don't know where to look for it, or you have a mountain of data and you don't know what it means. And so I would say that in every case, the team must be composed of forensic and legal working hand in hand together from the beginning to the end.
Merci beaucoup. And a question from anyone? I know we're close to the end. Okay, so I'm going to thank our panelists very much, and thank you for making the time. Thank you, FRA, for putting this together with us. And if, for those of you who have time, we can have a nice drink before we head off to dinners.
Can I say one more
Yes.
thing? Sorry. Equal Representation Expert Witness is a nonprofit organization that is aimed at promoting women in expert witnesses, arbitration, tribunals, and all of that. So take a look, see if that talks to you, because it's really important given the low level of women that are in tribunals or in expert witnesses. So if you can consider it, that would be great. Thank you.
Super. Merci beaucoup.
Good discussion.
Excellent. Excellent. Thank you.
Now we go for our corrupted part.
Now we
Corrupted part.
now we will happily be corrupted.
Yes, now we will be corrupted, yes.